You may introduce yourself and your client and proceed with your argument.
Thank you. Good morning, Adam Hescock for Nintendo McIntosh. I want to start with the case State v. Condizar, 212 VT 260 from 2020. I know Justice Eaton and Justice Carroll was on that decision, is familiar with it. It's one of the most recent decisions related to jury taint and jury irregularities. And I thought this case was appropriate for oral argument because there was some confusion in my mind on whether or not it's moving for a mistrial was a requirement for the first prong of the jury irregularity analysis, because in paragraph 26 of Condizar, the court specifically cites State v. Honorato 142 VT 99 from 1982, which was a case where the defense did not move for a mistrial. And so I did start my brief with an analysis and indicating on page 11 that it's appropriate for the court to take a jury irregularity analysis because the court has done so before in State v. Oronto, and as well in State v. Peters, which was an unpublished entry order, 220 Westlaw 4037981. However, if the court disagrees with that and decides that there's a bright line where the defense must move for mistrial, then I think it's important to move to the second part of the Condizar analysis under plain error, because in this case, the trial court did not do a thorough analysis based on my specific request once I identified the potential jury irregularity. And I think the state misconstrues the transcript, and I think part of it could be because counsel wasn't part of the court case, because just starting on page 132 of the transcript, that's when I first identified the potential issue and gave specifics of there being a Confederate flag on juror number 7's truck toolbox. It was about the size of a license plate. The truck was parked right next to my vehicle. Me and co-counsel attorney Ontel took pictures so that we could show proof that there was this potential irregularity. But when the court asked me specifically on page 133 of the transcript, what do you want to do about it? I did specifically talk not just about juror number 7 and the point that he might be biased himself, but I said I wanted to strike juror number 7. But I also wanted to determine if other jurors might have seen the license plate or have been influenced by it, or if there was any discussion. And the reason I said that is because this was at the lunch break. More than half the trial had occurred and there was a recess. And as I indicated in my brief, there was a very unusual situation where one of the jurors was speaking during my client's testimony. So the court's response to that was whether or not juror number 7 should be struck without any kind of questioning. And I said, no, I would be happy to do individual voir dire. So I specifically requested individual voir dire for juror number 7. Just the appropriate questions would have been whether or not he had spoken to any other jurors, whether there was any discussion about race related to the case. But ultimately, the state agreed to striking juror number 7. The court struck him without any kind of inquiry. So I think that was.
Hescock, may I just ask a question? Sorry to interrupt you. As I read it, the court did ask the jurors as a group whether over the lunch hour they had heard of anything or any kind of information had come to them which they heard outside of the trial. Why does that not bode for a finding that whatever happened before that is harmless error? Because the judge did ask the jurors to let them know if anything untoward had happened.
Well, the specific question was whether anything after lunch happened, and I had brought up whether or not there was any discussions or any specific influences. And so my intent on that was when they had opportunity to speak earlier in the day whether or not this juror number 7, had made any kind of racist jokes or any kind of just inappropriate comments. And the court then did specifically ask, should we conduct panel voir dire? Okay, well, it looks like my time is up.
You may finish your response.
Thank you. So this is important. It was just taking me too long to get to it. Is the court on page 135 of the transcript said, "What do you propose we inquire?" And so not what you propose I or the court inquire, but we. So we were specifically talking about voir dire between the parties in the court, not just the court voir diring and asking that one question that Justice Carroll brought up. So I clearly was asking for it. And then this last part on the bottom of page 135 of the transcript, I was making my point for panel voir dire, and the judge actually interrupted me. You can see where I'm cut off in the last part of 135, and that's when the judge said it's quite a reach. So
all right, you're gonna have to leave it there then.
Thank you.
Thank you. And counsel for the appellee, you may introduce yourself, your client, and proceed with your argument, please.
Thank you, Your Honor. Justices, may it please the court, Travis Weaver, Deputy State's Attorney for Windsor County, representing the appellee, State of Vermont. I want to focus my argument because I know time is brief on two of the issues I raised in my brief. One of which is that a lot of the discussion by the appellant just now is relevant if the appellant had met the threshold showing that there had actually been exposure of extraneous information. I think everything that the court's heard both today and from the appellant's brief is that there was a concern that there might have been exposure, but that there was never a clear showing that any other jurors were exposed to such information. And I think that's an important threshold determination that is assigned to the defense in this issue, and that if they do not establish that burden, there is no obligation on the trial court to make further inquiry regardless. A lot of what the argument has been focused on today is the juror bias of juror number 7. And one of the arguments I make in my brief is that that has never been considered on its own extraneous information. And it's typically been analyzed as a separate issue of whether there's an inappropriate juror with inappropriate bias. I tried to highlight the different frameworks that would require, because there's a different burden on different parties depending on which framework the court uses. All of that is to say is that the mere presence of juror bias on its own has never been shown to satisfy the exposure to extraneous information that a jury irregularity analysis otherwise requires. The other argument I wanted to focus on this morning was, even assuming that they had met that burden, under Canjor, the scope of the inquiry does look at the circumstances of the extraneous information. And here I tried to highlight a number of factors to basically convince this court that that limited inquiry, which was only a question or two about whether they had been exposed to information over the lunch break, was sufficient, assuming there had been some sort of exposure. One, the exposure was fairly vague. It was not clear cut. Two, it was, as I discuss at length in my brief, it's difficult to imagine, other than assuming that juror number 7 had actually said things that we have no evidence of, how the presence of a Confederate flag or the defense photographing the truck could have actually affected the jury's deliberations. Most importantly, I do want to draw attention to that period in the transcript that the appellant discussed, where there is a back and forth conversation about how in depth do we want to go on this, and whether or not there's a danger of drawing attention to something that the jurors may not otherwise have seen. And even the defense during that exchange agreed with that concern. So I agree that the defense initially sort of suggested that different inquiries be made, but after that back and forth, the defense very clearly seemed to agree with the trial court's approach that a limited inquiry was appropriate under the circumstances, so as to not draw too much attention to things the jurors may not otherwise have seen. I think the two simplest ways for this courts to rule in the state's favor in this case are to either find that the defendant never made the threshold showing that a jury irregularity had actually occurred. I don't think the mere possibility or concern that exposure may have happened has ever been found by this court to meet that threshold. Or two, even if the court finds that that threshold was somehow made, that the defense's acquiescence to that concern about not drawing attention to the issue rendered the trial court's decision for a limited inquiry as appropriate under the circumstances and under State v. Canjor. And unless there's any other questions, I would cede the rest of my time.
All right, I don't see any hands. Does the appellant have any time remaining?
Appellant has no